Yes, sir.
How's jail?
To be honest, it's not nice.
Great.
It's not nice at all. And
That makes me very, very happy because I hope it's one of the most miserable, rotten experiences that you ever had.
it is, sir. And I wish to never see it again.
The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturb, we don't always specify the disturbance.
I'm gonna find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Yes, sir.
Everyone's always out to get you, man. Don't let them. Mr. Wheeler, you're charged with possession of marijuana. It's elevated to a Class A misdemeanor because it's in a drug-free zone. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews in the state of Texas. You cannot afford a lawyer. Lawyer will be appointed to represent you. Does he reek of weed right now?
Yes, he does.
You reek so bad, I think I'm gonna get high just from you standing in front of me. Okay, please.
Yes, Your Honor, on
My God.
4/24, officer at Teeny's Food Mart in Harris County, Texas, saw a defendant making hand-to-hand transactions with an unidentified male. Officer believed the hand-to-hand transaction to coincide with the possession and distribution of narcotics and or marijuana. The defendant observed officer and placed a clear plastic bag that contained a green leafy substance inside the front of his boxers.
Mr. Wheeler is facing a Class A misdemeanor for possession of marijuana, but the key issue here is the location, a drug-free zone. That automatically elevates the charge, making penalties more severe. The defendant reeked of weed so strongly that even the judge joked about getting high just from standing near him. He gets the full penalty, especially if they argue he was selling, not just possessing. If he has priors, prosecutors could push for maximum sentencing.
Wheeler turned around and attempted to flee the scene. Wheeler was advised a dog would be deployed and stopped when he heard the dog barking. Wheeler was detained without incident. The green leafy substance was retrieved from Wheeler's person. The green leafy substance weighed at 0.5 ounces. Teeny's Food Mart is in a drug-free zone.
No more outbursts, so you're removed from the courtroom.
So this gentleman here was on bond for a case and he not picked up a new case. Did he have the bond conditions to not pick up any new cases? Wheeler. We tell you not to pick up any new cases while you're on bond. Otherwise, the PR bond that you get is revoked and you get put into jail. You were on bond for criminal trespass. You've now picked up another case, and also you're here and you reek of weed so bad, you must have just stopped smoking right now.
So,
Judge, actually, it's the other way around. He was on bond for the PON. That arrest was out of April 24th, 2024. And
Oh, I see.
He picked up trespass on April 24th.
Okay, so we're here on, I thought we were here on the weed case. So we're here on the
We're here on
trespass then.
both, Judge, because he never, so before he approached this court on the marijuana case, he has since picked up the trespass case. But he was on bond for the marijuana case before he approached here and picked up the trespass.
So I'm sorry, so he's charged with the criminal trespass here, not the weed.
Both.
Both, right, but what, the reason he's in front of me now is for a criminal trespass because that's the new case stuff.
It's on both. He's never approached, he's never been here on the possession of marijuana case. That happened April 24th. And on April 29th, he picked up the criminal trespass. He never approached this court on either case.
I have here that he signed conditions of bond on 4/24, not to pick up any new cases. And now, 5 days later, he's picked up a criminal trespass. I mean, am I wrong?
Oh, you're right, yes, April
No.
25th, it has judge's signature, yeah. It says, yeah, the defendant shall commit no crime and shall not engage in conduct that could result in his or her arrest.
It's not looking good for you, Mr. Wheeler. It's Altamirano, right?
Yes, sir.
Welcome back. Mr. Wheeler, I'm revoking your bond and I'm keeping you with me. He goes with you. Can you please appoint Mr. Wheeler a lawyer? And
$5,000 bond. They did not grant him a PR bond, mostly because he's on deferred out of the 232nd District Court for assault on a pregnant person. That's a different complainant. The complainant there was his sister. So.
Hold on, you want me to bring him out?
Sure.
Stephen, do you mind bringing someone out, please? Yes, sir.
I was just giving you a little preliminary before
Let's,
you brought him
I
out.
want to hear, I want him to hear it.
I understand. But, he went to probable cause court. They denied a PR bond. He does have family here and he is employed. And we're asking the court either for a bond reduction or for a, PR bond. He's been on deferred since January of last year.
Manuel?
And the assistant district attorney's already notified them that he has this case. We're not sure whether or not they're going to file a motion to adjudicate or not, or take any action.
Hey, he's in the holdover, when it goes out.
Okay, thank you. Go ahead.
Yes, sir.
Yes, sir, no, sir.
Yes, sir.
The East,
Yes, sir.
how's jail?
To be honest with you, it's not nice.
Great.
It's not nice at all. And
It makes me very, very happy because I hope it's one of the most miserable, rotten experiences that you ever had.
it is, sir. And I wish to never see it again.
The problem is you keep doing things to land you in there.
Yes, sir. And I will try my best to do more to not end up back in here, sir. I promise.
The road to hell is paved with good intentions, Mr. East.
I know, sir. Like,
On a very serious probation for assault of a pregnant person. And now picked up terroristic threat. You're now facing another year in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
yes, sir.
You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes,
I
sir.
don't even know what happened to your case. All I know is that you're on a serious probation
Yes, sir.
and now you've picked up another case. So let's see what happens
Yes, sir.
and whether you deserve to be let out.
Yes, sir.
Please.
On April 29, 2024, in Harris County, Texas, the defendant threatened to kill the complainant and the child that they shared together. Complainant felt in fear and pepper sprayed the defendant while on the phone with the 911. Defendant admitted to the threat, stating it was out of anger.
The road to hell is paved with good intentions. That's how the judge starts. And for Mr. East, that road is looking like a straight shot to jail, given his violent history and the nature of the new charge. The court might deny bail entirely or set it very high, The defense could also try to negotiate a plea deal to avoid a trial. If probation is revoked, he could serve the full sentence from his previous assault case plus time for this new charge.
What do you think? What other does he have any other prior criminal history from anywhere else, juvenile?
So Judge, his priors are all in county. He has assault of a pregnant person that he's on probation for against his sister and an AFM, which was, it looks like it was.
So he has another assault.
He has an AFM, from 11.
22.
I think it was the same.
It was refiled. So it was an AFM that was refiled to assault of a pregnant person.
That was the sister. The complaint was his sister.
Correct.
Not
The
the same
complainant on that
complaint.
case was his sister, and the complainant in this case is the child of, or the mother of
His child. He's not compensating baby mama.
Yeah, try not to. Did you make it?
Mr. East, what do you do with your life now?
Right now, I'm working at a thrift store. I'm not getting paid that much, but I'm getting paid just enough to take care of the child. And right now,
How are you going to take care of a child? You can't even take care of yourself, Mr. East.
I'm still learning. This is my first child, Your Honor. This is my first child, Your Honor, and
You know, the problem is that with all the anger that you have, if a child sees it, what are they going to do?
they're gonna feed off that same energy, sir.
Right.
And
They're going to be just like you.
thank
If they see you beat mama, threaten to kill mom, what are they going to do?
you, same thing, but I would never touch my mother, my child's mother. I would never. I would never.
Patient for the very same thing, Mr. East.
I understand, sir.
I don't know, Carl. I don't know. You know, I'm not.
He's a lifelong resident of Harris County, Your Honor. He's not a flight risk.
I'm not. My concern is the public.
I understand. And the conditions are right now, he does have a place to stay. He lives on Tidwell. The mother of his child lives at a different location. And he orders are here for him to not have any contact with either with her, the complaining witness.
What was the tipping point here? Why did he get so angry?
4 o'clock in the morning,
4 o'clock in the morning.
I had got a phone call from a girlfriend of mine because she was having some problems of her own, but I was sleeping and I didn't hear her phone call or her texts. So while I was holding the baby, I asked her.
4 in the morning.
4 in the morning,
Yes, sir.
I believe he responded to some text from another female judge, and that's what caused the altercation between him and his mother of his child, which is understandable. We've talked about this. But he did not assault her, and as a matter of fact, he was pepper sprayed himself during the course of the altercation after he made the threat. He admitted to the officers that he made the threat out of anger. He had no intention of following through on it. He is gainfully employed. He just started his job last week. Hopefully he still has it. He hasn't been bond forfeiture for. He's not failed to appear in court. He's not a flight risk.
I'll make you a deal, Mr. East.
Yes, sir.
The only way, because I think that everybody should be given a chance.
Yes, sir.
You weren't given a chance here. You're on probation, which is a serious.
Serious charge.
What I want to see, though, is you proactively addressing your anger.
Yes, sir.
The only way I will let you out is if you take it upon yourself 3 times a week
Yes,
to
sir.
do anger management classes somehow, some way.
Yes,
And
sir.
I want proof on a written piece of paper that you're actually doing some kind of anger management
Yes, sir.
3 times a week.
Can we make it 4 times a week? I'm sorry to interrupt you, Judge.
3 is sufficient.
You need to do something that's realistic.
Yes, sir.
Don't overkill because you're setting yourself up to fail.
Yes, sir.
All I want is you to address it. And the way that I can do that is by dangling a jailhouse key in front of you. So you hold the keys to the jail. I want you to do 3 anger management classes a week.
Yes, sir.
And I want you to bring it proof to me every Monday that you've done 3 classes a week.
Yes, sir.
And the first time you falter, I will yank the bond and I'm going to put you in jail. You now know that you have no one to bond you out. So if you go to jail, you will be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir. I understand.
Give you this one and only chance.
Yes, sir.
Make me proud. Don't fail me.
Yes, sir.
So we need to find some kind of anger management class. I'm sure that there are free ones. It is up to you to find it. It's not up to Carl. It's not up to your girlfriend, not up to
Yes, sir.
you.
Yes, sir.
And I want you here every Monday with proof in hand that you've done the anger management classes.
Yes, sir.
3 week. No dope, no alcohol. Carl, I'd like to know who the extramarital person is, and we need to cut that off so that there are no reasons for her to get upset or you.
Yes,
You
sir.
focus on one and you focus on that child.
Yes, sir.
Understand?
Yes, sir.
This is the only chance you're going to get from me. You will not get another one. If you don't believe me, look around.
I believe you on. I believe you on.
Jeez, make me proud.
Yes, sir.
Judge, do you want him to have no contact with the complaining witness, or do you
I would
want him to
say
have no
until
contact?
things are better, yeah, no contact and no weapon.
Present time.
Yeah. With this one and the other probation case as well. Yeah.
Understand, but
Yeah.
other probation case, the complainant there was his sister.
The judge is making it absolutely clear this is Mr. East's first and only chance to stay out of jail. As part of his conditions, he must enroll in an anger management program, attend regularly, and provide proof of his participation every Monday. Additionally, he is strictly prohibited from using drugs or alcohol for the next 3 weeks. If he fails to comply with any of these requirements, there will be no warnings, no second chances, only jail.
You want no contact with her also?
Yeah.
Okay, fine. Just want to make sure he,
It's probably already a condition of the felony probation. That's
well, I understand. I just want to make sure that he understands while he's here.
It's already stated that I shouldn't have contact with Malaysia triplet or have any.
Stop. You know what's expected of you.
Yes, sir.
That's the only thing that matters.
Yes, sir. Thank you, Your
Thank
Honor.
you, Your Honor.
Thanks, Carl.
On the bond, is it a PR or a reinstatement or?
No, it's a PR because he never got a bond
I
whatsoever.
wanted to make sure.
Yeah.
Come on.
Thank you, Judge.
Carl, thanks.
Last name already done.
Where have you been? Do I know you?
I mean, I hang out here and there, Judge. Yeah, for now.
Michael Jones stood before the judge after a clash with police. A homeowner asked him to leave, but tensions rose when officers arrived. He resisted, then tried to walk away, only to be stopped. His attorney objected. He was just walking. How is that a crime? The judge took a deep breath and prepared to speak. The courtroom fell silent.
Good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge. Does he need to be brought out, or do you, I don't know your process.
Mr. Jones, please. Yeah. It's only fair, right? Because it's his case,
You
so
didn't hear me.
it's only fair because it's his case, so we might as well bring it up.
No. He asked me to do this, and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
Okay,
That's my client.
he must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
You said Jones, right? Michael
Yes,
Jones?
Judge. Michael Jones. 2546980.
Hold on, before you leave, there's an attorney that's in the waiting room.
Okay. Ms. Beck?
Who?
Is it Celine Beck?
Yes, Judge.
Okay. Oh, yeah, I haven't seen her in a long time.
In the queue.
Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No?
Just losing?
so, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then
Right, but then cops get up there.
and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge.
behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, "We identified ourselves as police," so what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, "I'm the police, stop." We don't live in that kind of society. "I'm the police, I need to investigate you, so therefore stop," all day long. "I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter," all day long. But hey,
So-
I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw
So
signs.
the trespass investigation ceases because he's leaving.
The defense is pushing hard on the idea that this arrest was not justified and they might have a solid point, The officer claimed he smelled marijuana and that the defendant looked intoxicated, but where's the proof? No field sobriety test, no blood test, just an officer's word. If the initial stop or arrest was unlawful, anything found after that is inadmissible in court. For this reason, entire case could fall apart due to lack of probable cause. Let's see how the judge rules.
Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's
of
what it is.
investigation.
Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only.
right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be, it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
I didn't hear what happened.